Welcome to A Taste of Justice. I'm Professor Angela Mae Kupenda. Look, this is our final First Amendment video for the semester. We heard our final position statements on today. I plan to be back with you in the fall in August, recording on some of my other courses. But before I get started, let me tell you my line. I'm a professor of law at Mississippi College School of Law, have been teaching in business schools and law schools for almost 30 years now. I want you to know that all interpretations here are my own and are not to be ascribed to my school. Now today, we've been covering our current First Amendment conflicts. My students have done an amazing job with their position statements. Remember, they have to argue their position and the opposite position. And in class, they've each completed a 5-minute presentation. It had to be current about the First Amendment. There's a conflict and they have a strong position. They treated each other with respect and courtesy and pushed each other a little bit on some points. And so I'm just grateful. It was a wonderful learning experience, if I do say so myself. Now today was our second day of examining the religion clauses. And I think it's very appropriate that we had about a week on the religion clauses. My school is a religiously affiliated private law school. So therefore we have many students, and not just at religiously affiliated law schools, but all over. But in our schools, certainly there are students with particular religious views. Now, one really interesting point, because the students have told me so, I may have a student who has one religious perspective, but then another student who has a different religious perspective. And we saw that in class today too. So what I'm going to do, we had 7 final presentations. 5 of them are tightly related. I'm going to tell you about the first 5 and then make a few more comments about some of the questions we did not get to. And then I'll tell you about the other 2 that were also on religious freedoms and free exercise and the Establishment Clause. And then I'll point out some other comments on those too. So remember, the titles are at the bottom in the text box. And I want you to keep a record as to whether you agree or disagree with my students' positions. I am not telling their names to protect their privacy, and also because sometimes people change positions, as you will see when I get to the final position statement. Okay, so the first statement is titled, "The Free Exercise Clause is being violated in the name of coronavirus safety." So this student argued that the First Amendment includes the Free Exercise Clause. She says that in the name of keeping people safe, the government is violating religious freedoms. And she makes a number of arguments in her paper. She connects to some ongoing disputes that different churches and individuals are having with government. And she says, of course, some people would say that a content neutral, reasonable time, place, and a content neutral, reasonable time, place, and manner restriction would suffice, but that is not her view. Her position is that all restrictions on both religious institutions and secular institutions should cease. She says that religion is being discriminated against because some businesses are allowed to operate and some churches are having restrictions. She says that it is impermissible for government to treat churches as non-essential businesses. And she argues that religious institutions are essential businesses. You know, in the questioning we had in class, she made a number of additional arguments. She said, well, people who want to go to church in person, even if that places them at risk, they should be allowed to attend church because they have First Amendment rights. And someone said, well, what about if those individuals contract COVID as a result of the religious gathering and spread it to others? And her view was people should be allowed to go to church services if they choose in line with their First Amendment rights. And if people are afraid that they may come in contact with them because they may have COVID, maybe from the service or whatever, then those are the people who should stay confined to their homes. But others should be allowed to operate and carry on their life without any restrictions. So what do you think about her argument? Do you agree with her or do you disagree? Now let me go on to the next one. The next one is similar, but it's slightly different in some respects. Here is the statement. COVID-19 restrictions prohibiting members from attending indoor services in their church violates the free exercise clause of the First Amendment. And she also points to factually a number of cases and a recent ruling by the Supreme Court indicating that this is a current conflict. And she too points to that the designation of some businesses as essential and allowed to operate and designating churches as non-essential, she says is an affront to the First Amendment religious freedoms, the free exercise clause. Now, in her statement, she refers to the case Employment Division versus Smith. I don't know if you remember that case. Let me just go back a minute. Ordinarily, the rule is that free exercise rights of religion may not be infringed upon by the government unless the government meets the highest level of review, strict scrutiny, exacting. Why are you doing this, government? However, the court ruled in a case called Employment Division versus Smith, where there are neutral regulations, general laws, even though they may touch on religious freedoms or affect religious freedoms, the standard of review is the low level rational basis level of review. Now, in her paper, she argues that church services ought to be regarded as essential religious meetings, similar to businesses such as grocery stores, etc., similar to restaurants or what have you, where you can walk up or drive up. She said this would allow members of the church to worship in their religion. And it seemed to me that maybe her position was slightly different from the first presentation, because it seems that she was open to some restrictions being placed on churches, but she believed these restrictions should not target churches and it should not result in a complete ban, but that some may be appropriate. I hope I'm representing her accurately here. I'm going to take a pause and take a look for just a second. Okay, I took another look. I just wanted to make sure. So she argues that some restrictions may be appropriate, similar to the way government is doing with some of the other businesses. She believes that it could be appropriate to require social distancing and other things like that, even with the church. But she was opposed to a complete shutdown of churches because of the First Amendment free exercise clause. Now we have a third one. It is also similar, but there are some differences. This statement is, there is no pandemic exception to the religion clauses. So she says we have a religion clause. The religion clause of the Constitution does not have a provision that says religious rights go away in the event of a pandemic. Now, she makes a very interesting argument. Now, let me go back a minute. In a case called Lemon, the Lemon test, the first prong of that test said that government must have a secular purpose, that government should not be entangled with religion, and there must be some secular purpose when government passes laws. But here, she makes a very interesting argument. She says that the word secular has been so revered that it has become its own religion. So she says by government saying we have a secular purpose, that secular purpose has to do with safety and stemming the pandemic. She says the government has made secularism a religion itself, so therefore government is entangled in religion under her argument. Now, she's also opposed to governmental restrictions because she said, well, what about for protest marches? People are allowed to march and protest under the First Amendment. Why can't individuals gather the same way inside a church? And so she says that there is no pandemic exception to the First Amendment, to religious freedom. Therefore, government does not have leeway in that regard to create a pandemic exception where religious gatherings are concerned. Now, what do you think? Do you agree with her or disagree? Do you agree with the general sentiment of these three position statements, or is there one that you more strongly agree with or more strongly disagree with than the others? Now, we had two more, and these other two actually, they argued the opposite position from the first three. Okay, here is one. The position statement, his statement is disease and diocese. Some content neutral restrictions on worship services should be allowed during a pandemic. Now, what's really interesting is the first three, and these two, they're basically relying on the same cases. What is different is their application of the cases and the position they take. So in his statement, he says, well, some content neutral, reasonable time, place, and manner regulations ought to be permissible under the Constitution, even where they affect churches. He says that is not an affront to the free exercise of religion. Now, I marked this paragraph. He says that a total prohibition on religious or worship services would be going too far in his view. He thinks that the government can do things like saying for certain institutions, certain businesses, you can only have 20 or 30 or whatever percent capacity. And he believes that it would be appropriate to do that even where a church is involved. He's concerned that there, of course, he's going to give government some leeway here, but he's concerned that government does not demonstrate favoritism toward religion, nor favoritism toward secular purposes. So here, his position is not quite identical to the other three because he is allowing some governmental leeway, but he would watch that leeway very carefully. What do you think? Do you agree with him that some content neutral, reasonable time, place, and manner regulations by government would be appropriate even for religious institutions, or do you disagree? Okay, let me give you the next one, the fifth one. Here is her statement. Free exercise in COVID-19, why the rational basis test must apply to ensure public health and safety. Now, she's arguing for the rational basis test. Some of the other positions that we discussed, they said no restriction on religion, or only restrictions if the government meets a very high test. But this student says that a rational basis test should apply. Rational basis is a low level of review to give the government leeway on matters related to public health or safety. So her argument is she's relying on the Employment Division versus Smith case, I believe. The Employment Division versus Smith used a rational basis test, and maybe more than that, she did an interesting analysis to some of the other speech cases. Now, going all the way back in one of the first, maybe 3 clips on First Amendment, we talked about a case called Schenck versus US. And that case was not about religion. That case was about protesting the military draft during times of war. And the court made a statement that during times of war, free speech rights are less than they would be in times of peace. So her analogy is that during COVID-19, we're actually engaged in a war. So that in times of war, First Amendment rights, including the rights of free exercise or religious freedoms, are to be less than they would be in normal times. She also talks about that governmental restrictions on religious gatherings, in her view, is only an incidental injury. She says that church congregations can still assemble. They just have to assemble remotely, they have to assemble online, or they have to assemble with a lower capacity to meet the government's restrictions in order to promote public safety. So she believes that individuals can still exercise their right of religious belief. They just cannot act in the way they want to, they desire. And her view is that is permissible under the First Amendment. Do you agree with her or do you disagree? And you may say a lot of these are similar. They are. It's almost like if you look at the first one that was mentioned before, it is very much in favor of free exercise of religion and the rights of churches to gather in whatever way they see fit, regardless of any health consequences. The last one I just read to you is sort of at the other end of the spectrum. It argues that all government should have to show is just a low-level rational basis. We have to even during these times, the free exercise rights must give some because of public safety. So we have these two positions that are at opposite ends of the spectrum, but then we have the others that fit in at various parts. So which one do you agree with and which one do you disagree with? Now, I had a number of questions for them. Some of my questions I didn't get to ask because some of the students asked my same questions. And so I just pitched them out for you to think about. So one question, of course, was, what is the level of review? If government can do as they choose with low-level rational basis, Employment Division versus Smith, then that's a low level for government to meet, even where churches are involved, if it's a generally applied neutral law. But if government has to meet strict scrutiny, that means government has to have a compelling governmental interest, and the regulation must be narrowly tailored to that interest. Maybe the first presenter maybe was arguing an absolute right. That's an interesting argument, but that sort of takes me to the next question. The court has said that the right to believe is greater than the right to act on that belief. And I'm thinking about the first presenter's argument, and I'm wondering, what about other restrictions that the government places on churches? You know, there are capacity limits. Even before COVID, there were capacity limits placed on various buildings. There are all types of regulations that are placed. One student brought up, there were some cases involving a church that wanted to worship. They were snake handlers, and a given government had said, no, that's not protected. Snake handling in your services is not protected under the free exercise. So what about that? I didn't get to my question I had about the 1918-1920 flu epidemic. Now that's something for you to Google about. I was reading something the other day about that epidemic that lasted for several years, and what measures did the government take as related to churches. And I was just wondering if that could be insightful at all to our current conflict we're having today. Okay. Oh, it was an exciting day hearing their positions and seeing them engage with their classmates and with my questions, oh, they all did a great job. Now, when I say my students all did a great job, that does not mean I agree with everything they said. That means I believe they did a great job in supporting their positions with case law, in addressing the other side, and in just engaging with their classmates who may differ with them in terms of the constitutional application. The final two. The final two position statements this semester were also about religious freedom. Now, the first one said, employers should not be able to exclude female employees from birth control coverage based on religious freedoms. Now, this was just a fascinating statement. It includes issues related to health law. It includes issues related to con law and the Affordable Care Act. And it also includes issues related to privacy rights and a woman's constitutional protections as to contraceptives, and it relates to religious rights. So here, she was considering where there are organizations, a current conflict, a current case, where there are organizations that under the Affordable Care Act would have to provide birth control coverage to their employees, but the organization may say, no, we don't want to do that. We need an exception because providing birth control coverage as a part of the insurance policy is in violation of their religious beliefs. So she says, of course, there are some arguments different from hers. One argument is that if you force a religious institution to provide contraceptive coverage and is contrary to their religious beliefs, then you're forcing them to pick. You're forcing them to pick between overall health care for their employees versus their religious beliefs. But in spite of that, in spite of that conflict that employers may be in, her position was that her position is that the government's interest in eradicating discrimination based on gender is, in her view, a stronger interest than the organization's religious freedoms to deny the coverage. She refers to the Bob Jones case. In the Bob Jones University case, there was a school who said that as a part of their religious beliefs, they did not want to associate with Blacks. They did not want to admit Black students to their university. And the government said, okay, you can do that if you want. You're a private school, but you will not get the tax benefits because you're acting in a discriminatory way. And Bob Jones University brought suit and they lost. The court said there that unequal treatment, government was seeking to eradicate racial discrimination. So this student argues that yes, this organization, this may affect their religious freedoms, but she says that in providing contraceptive coverage, the government is seeking to eliminate gender discrimination and protect the privacy rights of women. What do you think? Do you agree with her or do you disagree? Now, I told you I don't give my students names. for their privacy, but also because they're free to change their positions as time goes on. It is not uncommon that a student will start working on a position statement with one particular view, and by the time they complete their work, they may have come to a different conclusion. So this final position statement, the student changed one word in her title. Let me read the title to you. Allowing the Catholic Social Services religious accommodations while contracting with city government in fostering children does undermine governmental interests in eradicating discriminatory practices in foster care. Now I'm going to explain this to you, but at first she said does not. So in other words, at first she came down on the side of the Catholic Social Services, on the Catholic Social Services side. And now she's changed and she comes down on the side of government. Okay, so here, and this is a case that is ongoing, and you can Google it, and I have some information below to help you find it, but it's called Catholic Social Services. The arguments were held, according to the student, on November 4th, 2020. So the city had a contract, and they were trying to get foster care for children to place them in homes. And in order to participate in the foster care program, an institution had to meet a number of requirements. The city was concerned that there not be discrimination in the process. Now, Catholic Social Services, they wanted to provide foster care to help the children find homes, but they did not want to place children in homes if the parents were gay, LGBTQ. They didn't want to place them. So they wanted an exemption, or an accommodation, so they would be allowed to discriminate on the basis of sexual orientation. And so the city declined to give them the accommodation. The city said the goal here, the city said it had a goal of placing children in foster care, but the second goal was to eliminate discrimination in the process. And here, Catholic Services wanted to discriminate based on sexual orientation in placing the children in foster care. They wanted to participate, but they did not want to place any children in homes where the parents were LGBTQ. So the student, as she worked on this, her initial thought was that Catholic Social Services ought to be given the accommodation, ought to be allowed to discriminate in this way. But as she worked on her paper and studied and prepared for her presentation, if I'm understanding right here, if not, I'm sure I'll hear from her, she came to an opposite conclusion. She came to the conclusion that just like in the Bob Jones case, where the court said, no, we're trying to eliminate racial discrimination, so Bob Jones could not participate in that tax program. She says here, the city is trying to eliminate sexual orientation discrimination in this process of placing foster children. So she, at this point, does not see a way that the city can accommodate the Catholic Services organization and maintain its interest in eradicating discrimination based on sexual orientation. Follow the case. But for now, I want to ask you, do you agree with her position or do you disagree? Look, after our last two, of course, I had more questions for them. You know, my questions were, what happens then when you have religious freedoms on one side, you have privacy rights on the other side, and they collide? Which should prevail? The court has not said that in every instance, one constitutional right is paramount to the other. So when privacy and religious freedom collides, what happens when religious freedom and eradicating sexual orientation discrimination or privacy rights collide? From my earlier presentations, I told you about what happens when religious freedom for the individual or the individual church collides with the government's concern for safety for its city or its community or its state. How do we handle these collisions? This takes us back to the preamble of We the People. And this takes us back to the question as to, is democracy messy, right? How do we resolve these disputes? And regardless of what view you agree with, I know you're going to agree with me on this. Learning about all of these, being able to sit and hear people who disagree with your position. That is a pathway to enlightenment. And enlightenment, I hope, is a pathway to freedom. And freedom, a pathway to justice, or at least to a taste of justice. Thank you for such a great semester. And again, I plan to be back and hope to be back in August in the fall with some more YouTube clips for you as we learn more, as we seek justice, or as we seek at least a taste of it. Thank you, and you take care.